Is the prosecutor still in the room?
Yeah.
Yes.
Elijah Wheeler is here for a show cause. Is that, if that's not adjudicated, do you have an offer on that?
I'm writing it up right now. I know he only has about 3 tickets that show up on the docket.
Oh,
but
okay.
He actually has about 25 or 30 counts.
Oh,
So,
wow. Okay. So he did not get his license, but he said he got his vehicle taken care of. I haven't gotten proof of that yet, but.
LaShonda here. I'm sorry, I had got disconnected.
Shonda, you're gonna have to pull over while we do the hearing so you don't go off and freeze, okay?
I'm in the car, I'm not driving.
I know, but sometimes it freezes up and then we have to wait and it delays court
Okay,
hearing.
pull over.
What's her last name?
Weaver, pull over.
It'll be real quick, Miss Weaver, okay?
Okay,
All right.
okay, I'm ready.
I'm just your matter.
Ms. Weaver, were you in the breakout room or the waiting room? Did you talk to the attorney already?
Yes, I talked to her.
Okay. What judge?
I'm gonna just do it. It's okay.
Okay.
Cool. All right. Now calling the matter of the people versus LaShonda Weaver. This is ticket number P1207001. This is account 3, drive unregistered or untitled vehicle. Today is the day and time set for a review of this matter. Ms. Weaver was to have done 25 hours of community service. May I have your name for the record, please?
LaShonda Weaver, LaShonda Weaver.
Thank you. Ms. Weaver did have an opportunity to complete the community service. I have a compliance report in my file, so at this time, we're going to close out that matter due to the fact that she was able to complete community service, okay?
Okay.
All right, there's nothing further. That concludes this hearing. Have a good day, Ms. Weaver.
Do I pay a restatement fee or I can get my license back?
So if there's a reinstatement fee owed, you have to pay that. That's $45. Did you check online to see?
No, because I didn't have my case number and I need a case number.
You need the case number?
Yes.
Okay, you ready?
Yes, I'm ready. I'm ready.
Okay. It's P1207001.
P12.
07001.
Okay, P1207001.
Yes, ma'am. Okay.
Thank you.
Counts 1 and 2 have been dismissed. It looks like, but count 3 is the one that you need to look at, okay?
Okay, thank you.
You're welcome, Ms. Weaver. Have a good day. Ms. Carver, while you're waiting on that offer, are you ready on everybody else?
I think so, yes.
Basha, right?
Who's in room 5?
Basha, right?
Room 5 is Lenise Williams, okay?
I
No,
think,
room 5 is nobody.
okay,
It's Arlisha Williams, okay.
good.
Now calling the matter of the people versus Basha Wright. This is ticket number X 3811701. This is count 1, no operators license, multiple operators license on person. Appearances for the record, starting with counsel, please.
Jane Carver on behalf of Ms. Wright. Ms. Wright, can you state your name for the record, please?
Basha, right?
Today is the time and date set for trial. The officer has not appeared and we move to dismiss this ticket.
Time is now 10:38 a.m. This matter was scheduled for 9 a.m. No officer having appeared on this matter, the court is going to dismiss it without prejudice. Ma'am, you're all set for today, okay?
Thank you. Have a good rest of your week.
You too. Thank you so much, Ms. Wright.
And-
Right.
And I do have the registration and insurance for Mr. Wheeler as well. If Mr.
Okay, we'll get that in a minute, Ms. Carver.
If Mr. Gillis is there. Thank you.
Now calling the matter of People versus Chantel Williams. This is ticket P 1221784, one count no insurance misdemeanor. Ticket number P 1199125, one count careless driving. Today is the date and time set for a bench trial. Appearances for the record, starting with counsel, please.
Jane Carver on behalf of Ms. Williams. Ms. Williams, can you state your name, please? Williams, you're on mute.
Yep.
Chantel Williams.
Oh. Say it one more time, Ms. Williams.
Chantel Williams.
Much better, thank you.
Today is the time and date set for trial, and the officer has failed to appear. We move to dismiss.
Time is now 10:39 a.m. No officer having appeared, the court is going to dismiss this matter without prejudice. Ma'am, they can refile this if they want to, but as of today, you're all set, okay?
Thank you.
You're welcome. Have a good day. Ms. Walker?
Okay, yes.
All right. Now calling the matter of People versus Keela Walker. This is B ticket 113631, one count parental duty. Failed to exercise reasonable control. Ticket number P 1118111, count 1, allowing an unlicensed driver to drive. Count 2, no insurance misdemeanor. Ticket number P 1249802, one count, allowing an unlicensed driver to drive. Case number SP 13053161, one count disregard signal red or amber. Case number SP 1308901, failed to display a valid operator's license not on purpose. Appearances for the record, starting with counsel, please.
Jane Carver on behalf of Ms. Walker. Walker, can you state your name for the record, please?
Keela Walker.
Ms. Walker would like to set these matters for a bench trial date. I think you read a few that were not on the docket that maybe should be set for a formal hearing, or the defaults might need to be set aside.
This time the court's going to set aside the defaults that have been put into play. They're not defaults yet. They're pending. She doesn't have a hearing until November the 9th. But I just brought all her cases together so she doesn't have to go to a whole lot of different courtrooms, okay?
Okay, thank you.
She didn't miss any court dates on these. Well, on one of the tickets she did, because it's a 2018 ticket, but the other matter, and then on the P 1118111, that's arraignment on the bench warrant too. How do you stand your client mute on both of those cases?
Enter, you can waive the reading and we enter a plea of not guilty.
The court will enter pleas of not guilty on your client's behalf. Ma'am, it's my understanding you want a bench trial before myself?
Yes, ma'am.
If so, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Ms. Walker, did you have an opportunity to talk to an attorney in private about your case and about your rights?
I did.
And it's my understanding you want to have a bench trial before myself as the trier and finder of fact?
I do.
All right, ma'am. I'm gonna set it for a bench trial on the date of November the 8th, 2022 at 9 a.m. I'm gonna set your bond at $0 personal, okay?
Thank you.
I'll see you then, 9 a.m. via Zoom. Are you writing it down, ma'am?
Right, I'm trying to write it down right now. You said November 8th. I'm sorry, Your Honor.
No, I understand. No. When I see people get up to do that, I know they're looking for a pen, so I understand. November the 8th. Got it.
Got it.
9 a.m. same Zoom information, okay?
Okay,
Bond
thank
set
you.
at $0. You're welcome. Bond set at $0 personal, okay?
Thank you so much.
You're very welcome.
Have a good day, Your Honor.
You too, thank you.
She said that she was just gonna show.
All right. Okay.
Think you finished writing up the recommendation.
She might be short.
Now calling the matter of the people versus Layla Wolflong. This is ticket number SP 136744472. One count, no insurance misdemeanor. Appearances for the record, starting with counsel, please.
Jane Carver, on behalf of Ms. Wilfong, can you state your name for the record as well?
Layla Wilfong.
Ms. Wilfong has provided insurance that expires in December of 2022, and we move to dismiss this ticket for valid documentation.
And as officer of the court, you've seen that document?
I did.
All right. So at this time, the court is going to dismiss it without prejudice for valid documentation. Ma'am, make sure you always keep everything up to date and valid, okay? Okay, Ms. Wolflong?
Yes, okay.
Okay, all right. There's nothing further. You're all set, okay?
All right, thank you. Have a good day.
You're welcome. Have a good day. You talked to Ms. Williams about her plea offer?
Arlisha?
Yes.
Yes, we would like to set that for a trial date. I know it's a arraignment on a bench warrant,
All right.
but I talked to her.
Ms. Williams?
Good morning.
Morning. Okay, give me a date. All right. Now calling the matters of the people versus Arlisha Williams. This is Z ticket 8072991. One count operating with a high VA blood alcohol content of 0.17 or more. Ticket number SP 11435903. One count driver's license never acquired. Ticket count. Nope. Ticket number SP 11602202. One count, no insurance misdemeanor. Ticket number SP 11602203. One count driver's license never acquired. Ticket number SP 116022691. One count failed to display a valid operator's license not on person. Ticket number SP 7097402. One count drive unregistered or untitled vehicle. Ticket number SP 7097303. One count no insurance misdemeanor. Ticket number SP 7358701. One count improper plates. Ticket number SP 7358702. Drive unregistered or untitled vehicle. Ticket number SP 7358703. One count failed to display a valid operator's license not on person. Ticket number 135049811. Failed to display a valid operator's license not on person. Ticket number 162132811, one count drove while license suspended. Case number 162132813, no insurance misdemeanor. Case number 163029631, one count no operator's license on person. Ticket number 163029632, one count drive unregistered or untitled vehicle. Ticket number 163029633, one count no insurance misdemeanor. Ticket number 144339131, one count failed to display a valid operator's license not on person. Ticket number 144339132, one count drive unregistered or untitled vehicle. And ticket number 144339133, one count no insurance misdemeanor. Appearances for the record, starting with counsel, please.
Jane Carver on behalf of Ms. Williams. Ms. Williams, can you state your name for the record, please?
Yes, Arlisha Williams.
Ms. Williams would like to set this matter for a bench trial date and ask you to enter a plea of not guilty and waive the formal reading.
Is that right, Ms. Williams? You want to put all these matters for a bench trial?
Yes, ma'am.
If so, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Just put your hand down. Ms. Williams, did you have an opportunity to talk to an attorney in private about your case and about your rights?
Yes, ma'am.
My understanding, you want to have a bench trial. That's a trial before a judge that's a trier and finder of fact. Is that how you want to move forward, ma'am?
Yes, I actually wanted to, yes.
Okay. Did you have a bench trial scheduled already for these matters?
I'm not sure. I actually passed my test for nursing school, so I'm just trying to clear everything that I need to clear to get so I can start school or whatnot. I don't believe I had a trial or anything before.
All right. It's gonna be on November the 14th, 2022. It's gonna be via Zoom. So the same way you zoomed in today, you're gonna zoom in on that day. I'm gonna set your bond at $0 personal on all of these matters. And we'll see you back then on that date and time, okay?
Okay, I believe that's the day I start nursing school. But I guess I'll just have to alter that. That's perfectly fine. I'll figure it out.
One second, let me see if I have a different day. Is nursing school every single day?
Monday through Friday, I have my schedule here, and that's my start date, November 14th. 9 to 3.
Hello?
Excuse me one second, we're in the middle of having a hearing. Well, prior to November. Oh, you want some prior to? Like I was just trying to get that. might have to be the 14th. I'm trying to find another day, but you have so many tickets that
I,
yeah. It might just have to be the 14th. I was trying to find some day before then, but I'm sorry, Ms. Williams, okay?
that's fine. I'll figure it out. Thank you, Judge.
You're welcome. Have a good day, okay?
You too. Thank you.
What that? Hold on one second, Ms. Williams. We're trying to figure it out.
Okay. Thank you.
I'm just gonna go speak to Mr. Wheeler.
Okay. How about October 7th, Ms. Williams? Does that work for you better?
That's perfectly fine.
Just on the record real quick, Ms. Williams had a conflict, with the date of November the 14th. The court did look at his docket. We're gonna try and put her on and accommodate her on October the 7th for a bench trial on all the matters previously said. It is still gonna be at 9 a.m. and via Zoom, okay, Ms. Williams?
Okay, thank you. I appreciate it.
No problem, I understand. All right, there's nothing further. That concludes this hearing, okay?
Okay, have a great one.
You too, thank you. Bye-bye. Ms. Twyland, what's your name, ma'am? What's your name, ma'am?
Taiwan Williams.
Were you already signed in today, Ms. Williams?
No. I'm at work. I actually forgot that my court date was, I think it was 9:30 or 9:45. And when I realized that I came in and I was actually at another courtroom in the wrong one.
Is that the correct spelling of your first name, ma'am?
Tywann.
We don't see you on the docket. Can you call the courtroom, please?
I'm not. I thought it was for today. They rescheduled it for the 15th. Supposed to have been a bench trial. Am I in the wrong courtroom again?
No, you're in the right courtroom. You're not on our dock. You have a case number, ma'am?
Oh, no, I don't have it with me.
All right.
Okay, can you call the courtroom then?
Okay, thank you.
You're welcome.
You got the number?
No, well, I guess I can take it. I was gonna just look it up from Google it.
You ready?
Yes.
313.
Huh?
313. 965.
Okay.
2293.
965-2253.
993.
965-2293.
Right.
Okay, thank you.
You're welcome. You just got. What's that name, wait? Okay. Spell it. I mean, you write them in. Yes.
What?
Did you talk to Lanice Williams?
Yes, she should have come out. Oh, well.
Okay. Lanice Williams?
Yes. On my shirt.
Now calling the matters of the people versus Lanice Williams. This is case number SP 11239662. One count improper play. Ticket number, case number 18504-792. One count allowing an unlicensed driver to drive. Case number 18504-7922. One count open alcohol in a motor vehicle passenger. Ticket number P11963. One count drove while license suspended. Count two, drive unregistered or untitled vehicle. Count three, no insurance misdemeanor. Ticket number P1237365. Count two, no insurance misdemeanor. Count three, drove while license suspended. Ticket number SP893881. One count, no insurance misdemeanor. And ticket number SP112396661. One count, drove while license not valid or improper license. Appearances for the record, starting with counsel, please.
Jane Carver on behalf of Miss Williams. Ms. Williams, can you state your name for the record, please?
Lanice Williams.
Yes, Miss Williams has provided proper documentation. She has a valid license, her car's registered, she has valid insurance. So we moved to dismiss the counts that are related to driver's license suspended and improper plates and the no insurance counts. There are 2 counts that we'd ask you to set for a trial date, a bench trial date, the allowing an unlicensed driver to drive and the open alcohol in a vehicle.
What's that? Oh, yeah, I'm sorry, I was thinking about something.
All right, having been an officer of the court and seen the documents, now that she has valid documentation for her license, for her title and registration of her vehicle and for car insurance, the court is gonna dismiss those cases that deal with those matters. On the other 2 matters, it's my understanding, Ms. Williams, you would like to have a bench trial?
Yes.
If so, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Ms. Williams, did you have an opportunity to talk to an attorney in private today about your case and about your rights?
Yes.
It's my understanding that you would like to have a bench trial. That's a trial before a judge, that's a trier and finder of fact. Is that how you want to move forward, ma'am?
Yes.
All right. All right, I'm gonna set these matters, ticket number 1850479, 2 counts 1 and 2. I'm gonna set them both for a bench trial on the date of November the 8th, 2022, November 8th, 2022, via Zoom. So the same way you zoomed in today, you're gonna zoom in on that date. Your bond is gonna continue right now to $0 personal, okay?
You said November 8th at the same time, 8:45 a.m.?
At 9 a.m., okay?
Okay.
I said your bond is gonna continue. It's gonna be the same,
Okay.
okay?
Yeah.
All right. If there's nothing further, that concludes this hearing. Thank you.
Thank you.
Thank you.
Wheeler. Mr. Wheeler?
Ma'am, how you doing?
I'm good, thank you. Now calling the matters of the people versus Elijah Wheeler. Ticket number P1062149, 1 count driver's license expired. Ticket number P961676, count 1, drove while license suspended. Count 2, no insurance misdemeanor. Count 3, drove unregistered or untitled vehicle. Ticket number P1280716, 1 count expired plate. Ticket number P1251953, count 1, drive while license suspended. Count 2, no insurance misdemeanor. Count 3, expired plate. Ticket number P1335855, count 1, tinted windows. Count 2, no insurance misdemeanor. Count 3, drive while license suspended. Ticket number P1229080, count 1, drove while license suspended. Count 2, drive unregistered or untitled vehicle. Count 3, no insurance misdemeanor. Ticket number P1280714, 1 count drove while license suspended, repeat offender. Count 2, no insurance misdemeanor. Ticket number P1251955, 1 count disregard, signal red or amber. Appearances for the record, starting with counsel, please.
Jane Carver on behalf of Mr. Wheeler. Mr. Wheeler, can you state your name for the record, please?
Sorry, I didn't hear the last.
Could you just state your name for us, please?
Yeah, not a problem. Elijah Wheeler the second.
Mr. Wheeler would like to take advantage of the prosecutor's offer and enter a plea today.
Is that right, Mr. Wheeler?
Yes, ma'am, that is right.
All right, if so, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Mr. Wheeler, did you have an opportunity to talk to an attorney in private today about your case and about your rights?
Yes, ma'am, I did.
Anyone threaten you, force you, or promise you anything in exchange for a plea today?
No, ma'am.
Are you pleading guilty of your own choice?
Yes, ma'am.
Are you pleading guilty because you are guilty?
Yes.
And do you understand that by taking this guilty plea, that you're going to give up any rights that you may have had to have a trial in the future?
I do not. I'm okay.
You said what?
Yes, ma'am, that's fine.
Okay. Understanding all of that, did you still want to move forward today?
Yes, ma'am.
All right. I want to take your attention first back to the date of February 1st of 2020. At that time, were you driving a Jeep vehicle in the area of West Auto Drive and Southfield Service Drive in the city of Detroit?
Yes, ma'am.
And while you were driving that vehicle, was your driver's license expired?
I believe so, yes, ma'am.
Okay. Also looking at the date of March the 2nd of 2019, were you in the area of 8 Mile and Hoover in the city of Detroit driving a Jeep vehicle? And while you were driving that vehicle, was your license suspended at the time?
Honestly, I'm not exactly sure when my license did get suspended, but I'm probably more than sure that it was because I never taken care of possibilities.
It's breaking up, Mr. Wheeler. I don't know, you got a lot of background noise, so you're gonna have to repeat that.
I'm sorry, I don't know if it's my headphones, but yeah, I'm not for sure when they did go suspended, but I'm more than sure that it was because I wasn't taking care of what I needed to. So I'll just go ahead and say yes, it was.
Okay. And did you also not have any car insurance on that vehicle at the time?
Right.
Is that
Yes, ma'am.
yes?
Yes,
Okay.
ma'am.
Reading from the ticket that on the date of November the 28th of 2021 in the area of Curtis and West Auto Drive in the city of Detroit, Mr. Wheeler was driving a Dodge vehicle and the plates were expired. Satisfied, Attorney Carver?
Satisfied, yes.
Stipulation for probable cause on the remaining counts to be dismissed.
Yes.
So at this time, the court's going to enter a plea to the amended charges of improper plate on ticket P 1062149 and ticket P 961676, counts 1 and 2 to be amended to improper plate. Ticket P 1280716, that count of civil infraction is as charged. The remaining counts called on this record today will be dismissed. Sir, the fine for expired plates is $145. It's typically due 14 days after you take the plea. Is that gonna be enough time for you, sir?
Yes, ma'am.
All right. So I'm gonna have you do no later than August the 29th of 2022 for that. On 2 of the other tickets, I'm gonna charge you $200 per ticket, so that's $400 total on ticket P 961676, okay? So that's $400. How long will that take you to pay? 30 or 60 days?
I could do 60.
60, okay. We'll have to do no later than October 17th, 2022. All right, the last ticket, I'm gonna waive your costs and fines for it. You're probably gonna have these things called reinstatement fees. You're gonna have a few, okay? It's gonna be $45 a piece. You may have a lot, you may only have a few, but you're gonna have to pay those, and you have time to pay those, but in order to try and get your license back, you're gonna have to make those payments, okay?
Okay.
All right, so you got any questions, Mr. Williams?
No, ma'am.
All right, if not, thank you for your patience today, Mr. Williams. So we have
No
$400 by October the 17th.
Okay.
The $145 is due on August 29th of 2022, okay?
Okay, and I just go to the 36th district and just,
You can either come down to 36th District Court, or you can go online and pay it at 36districtcourt.org, okay?
Oh, okay, bet. Okay, thank you so much then.
You're very, very welcome. Good luck to you, okay?
Thank you so much. You enjoy the rest of your day, man.
All right, you too.
And I'm okay to leave now, right?
You are okay to leave now. Sergeant Burton Harris, do you have her case number, Ms. Wallace's case number?
I can grab it for you real quick, Judge.
Can I have it, please? I need to get a printout.
Sure. It's 2 cases. One of them is 22-000-303-01-.
That's the circuit court number. Do you have the other ticket
Yeah,
number?
I'm sorry. I'm looking at the lower. Yeah, I was looking at the wrong thing. Give me 1 second.
Okay.
Okay, sorry about that. I have it now when you're ready.
Okay, I'm ready.
Z808. I should say Z808.
Uh-huh.
211. The case code is OM.
All right.
I might need to go to a breakout room with Ms. Wilson.
I don't know who this is. She signed in while we were having our final hearing.
Oh, okay. She's on the docket, show cause,
Oh, is she?
no insurance, yeah.
Trying to figure out why she just came online recently, Ms. Wilson.
Oh, Judge, I should have said for Ms. Wallace's case, there are 2 tickets. One ends in 611, the other one ends in 612.
Yep, I was about to say, they usually on the same ticket thing, so I know she had 2 counts. One was interference with the police doing their duties.
Yes,
And the other, I can't remember what it was.
it was loitering, impeding pedestrian or vehicular traffic.
Yes, 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 yes. Ready? All right, Attorney Burton Harris. All right.
I'm ready, Judge.
Now calling the matters of the people versus Nakia Harris. This is case number Z80826 Count one, interfering with government employee performing their duty. Count two, impeding pedestrian and or vehicular traffic. Appearances for the record, starting with city attorney, please.
Good morning, Your Honor. John Gillis, P79500 on behalf of the people of the city of Detroit.
And Attorney Burton Harris.
Good morning, Judge. Robert Burton Harris, P81843. I am representing Ms. Nakia Wallace on behalf of the Detroit Justice Center for this case. Ask Your Honor's permission to waive her presence for today's purposes.
At this time, the court will allow you to waive her presence for this purpose of this hearing solely. Attorney Burton Harris, you called the courtroom this morning and you had a question or concern. Can you please place that on the record?
Yes, Judge. So you are accurate. I contacted the court this morning to inquire as to our preferred procedures for correcting a scrivener's error of an order. As some background, I'm sure you're familiar with this case. This case has been going on for a while now. And right now what the case is that the case has been, is in circuit court on the city attorney's delay application for leave to appeal. It has not been accepted. So the circuit court does not have exclusive jurisdiction over this. And also, Your Honor, if you recall, you granted a stay in the proceedings. So what I'm asking for is for the order that is the subject of the appeal to be modified insofar as there was an error in the original order. Specifically, the order says that a hearing was conducted on December 20th, 2021. And that's when Your Honor issued the order for the evidentiary hearing. That is the subject of the appeal. The issue is that that order is not accurate insofar as there was no hearing on December 20th, 2021. The hearing was actually on November 29th, 2021, when Your Honor issued the opinion and ordered, not issued the opinion, but ordered that we needed an evidentiary hearing for you to make a decision on our motion to dismiss based on a vindictive prosecution claim. That oral order was issued and actually entered into the Register of Actions on November 29th. There's no Register of Actions indications that anything happened on December 20th. I've spoken with previous counsel, and again, no hearing was actually held on December 20th. So I'm asking that the order, the scrivener's error, be corrected to reflect the date that the order was actually entered into the Register of Actions and actually effective. Because the evidentiary hearing, notices to appear even went out before December 20th. So that's why I'm asking for the correction. And I think that's important before we go back to circuit court this afternoon, because the issue right now in circuit court is whether or not the city's application for leave was timely or untimely. I think that it's pretty uncontested that the deadline for them to file their application for leave, going by the December 20th date, would have been January 10th of 2022. They didn't file the application to leave or for leave until January 12th, 2022. And so that's why Judge Cox in the circuit court hasn't ruled or accepted their application for leave. And we're appearing in front of him this afternoon to get to the bottom of the actual timeliness of it. So instead of waiting and even requesting a remand from him to correct this order, I've looked at the court rules and talked to some other appellate attorneys, and there's nothing that precludes you from correcting it because it is a scrivener's error, and also because the jurisdiction does not rest solely in the circuit court. So that's what I'm asking Your Honor to do.
Response?
Your Honor, respectfully, I would object. I do believe that the jurisdiction lies with the Wayne County Circuit Court. I do think the timing of counsel's request is curious, given that in less than an hour, we are going to be appearing before Judge Cox on both a motion to dismiss and oral argument. While I would concede that he hasn't accepted our application for leave to appeal, that is only because there is a motion to dismiss that must be heard beforehand. He is planning on hearing oral argument today. With that being said, I believe that this is an issue that should have been raised on appeal by counsel, and I believe that it lies in the circuit court's jurisdiction. So I would object for that reason, Your Honor.
And just brief response.
Go ahead.
Further counsel concedes that the application for leave has not been accepted. So no, jurisdiction does not lie exclusively in the circuit court. According to MCR 2.6112 subsection E, that is the section of the court rule that deals with release from judgment and also orders. And it's expressly in there that clerical errors can be corrected by the trial court at any time for any reason, and also via sua sponte. You don't even have to actually have a party ask for the correction for them to be for it to be made. And there's also specifically in MCR 7.208, subsection A and C, the court rules actually expressly deal with a situation like this where an application for leave has been filed, but has not been accepted by the court. And an order or whatever needs to be corrected at the trial level. And in both of those subsections, it makes it very clear that Your Honor is able to correct any defects in any type of order and also correct any part of the record that is actually being dealt with in the circuit court. So you have 100% the ability to correct this error. Just asserting that you don't, and that's just not sufficient.
Well, what's the error though? Because there was, so I can check my email. So I didn't issue the written, so the written order wasn't signed until, I'm looking at it. It wasn't signed until December. So what's the error that you're alleging?
Well, the error it actually should have been the order was signed on December 20th, but it was actually issued and entered on November 29th. So that order for the evidentiary hearing.
Why would you make that argument at the upper court? I'm not understanding.
Because the upper court. Because the upper court will have to remand with instructions to you to amend the order to reflect when it was actually entered. And it was entered on November 29th, not December 20th. What happened on December 20th was it was the last day for the prosecutors to file an application for leave. So I believe that they contacted your court without contacting us and asked you to sign an order for that evidentiary hearing. But the issue is that they should have put at the top that the date that this was actually dealt with in front of you was on November 29th. It was not December 20th when they asked you to sign the order. And it was effective, and we know it was effective before December 20th because notices to appear had been already issued per the Register of Actions. Orders are effective once they're entered. And if they haven't been entered, then we look to when they were signed. But because in this case, the November 29th court hearing, you ordered it orally and it was also entered into the Register of Actions, the actual order itself should reflect November 29th and not December.
Okay, maybe I'm looking at this wrong, but help me understand. So I made the ruling on November the 29th, but they have so much time to leave to appeal. And they did that within the time period, right? And that's reflected that they did that by that December the 20th time.
No, that's the date that they put on the order. They actually didn't even get the motion, the application for leave to appeal filed until January.
But that's not for me. If the date that I entered it in, if the date that I signed it is December the 20th, right? So if I order if I did it on these dates, if I did the date and I made the hearing on November the 29th and I signed it on December the 20th, what is there for me to correct? Help me.
Because so the order just says at the top that at a hearing at that date, and that date was December 20th, the following happened. That's incorrect. The hearing was on November 29th, where all of the stuff that's actually in the order actually occurred. So if they want to argue that this is not effective, because the order is effective on entry. So if this hadn't been entered into the Register of Actions, then I wouldn't even have bothered Your Honor with this. But the fact that this was already entered into the Register of Actions, that's the date that controls. You can't subsequently say, okay, well, we're just going to sign it. So basically, it would give an appellant more time than the 21 days allotted if it was a matter of the date of entry or when it was signed, whichever one's later. And that's not what the court rule says.
Okay. So you're saying the actual order. I just have the plaintiff's motion of proceedings. Let me see if I can find the order.
And I have a copy of that if you, I'm sorry, I didn't mean to cut you off, Judge.
It's okay. I have in the actual motion that the date, and maybe that's why I'm confused. The motion says on November 29th was the hearing scheduled. I don't know, she issued a written order on December 20th, 2021.
Judge, if you're speaking to me, I think you're muted.
I'm not on mute. I'm talking to myself.
Oh, I'm sorry. I didn't hear you.
I'm trying to find documents and stuff, you know, when you, the day of, you gotta look for stuff. You gotta
I
try and
understand.
find.
And
You
to
gotta
the-
look for- this has been going on. We had lots of hearings, so I got transcripts. And so now
I know.
I'm trying to figure out what it is.
I know I've spent the last about 7, because I just got on this case and I filed an appearance this morning. So I spent the last 3 days, getting acclimated to everything and reading everything. So I understand a lot has happened.
If I can even find the transcript. Off the record. Let me see if I can find the transcript.
And if you need to, Judge, I have the November 29th transcript. I can send to you if you need.
Yeah, I do.
I know, I got them too. They just upstairs in the office.
Hey, John, are you there?
There we go. Sorry, we were muted.
No, that's fine. How you doing this morning?
I'm doing well. How about yourself?
Cool. Yeah, I'm getting into the weeds of this. This has been, it's like that old litigation from the Hamburg 9 case I was involved in. Just a lot of stuff.
Yes.
Question for you: Did DJC file a reply to your response to the motion to dismiss in circuit court, or was the supplemental brief the only thing that was filed after you filed your response?
The supplemental brief that was filed last week was the only thing that was filed after my response.
Okay. All right. Just making sure I didn't miss anything.
Gotcha.
So you want me to give it to? Will she come in?
Yeah, you know what? One of the judges out, I'll just run. And then text her, but.
Get it now.
Did you find it, Judge?
I did.
Okay.
I just come down, went upstairs.
I was gonna email it to you. I had it all queued up. Okay.
They had to go see if they could get somebody different. Our council had to leave for this matter.
Did you, was there another prosecutor scheduled to return for your, the rest of your docket?
Until 1:30.
You have three of them. You ready for the fifth one?
We're waiting. They're gonna send someone. He's gonna try and get somebody to come down right now, hopefully.
You have fifth one? No, that's all. You have fifth one?
Ms. Carver, you finished with talking to Ms. Wilson?
Okay, just go ahead and answer.
You're on mute.
Yes, she's supposed to send me her insurance. Is she still in the breakout room? I still haven't received anything yet.
Just let me know when you do.
Okay, thanks.
You're welcome. Ms. Carver? She was looking at her. That's why.
Yes, Your Honor.
She has additional tickets.
Oh, no.
Yeah. She got a whole stack of them and she came in late.
Well, we have, I've I reviewed her insurance that is valid now.
She still has, let's see. Oh, she did pay some. Yeah, I see she ended up paying some. She still has a what's that? 11 to 15 mile over speed, failed to yield the right of way, no insurance misdemeanor, expired per late. But she paid some of her tickets. So let me see. Get some worked out.
Is the prosecutor still in the building?
Well, we can ask Ms. Walker if she's willing to talk to you in a breakout room about it after I finish this last matter. Okay?
Okay.
Thank you for signing on, Ms. Walker.
Yes, Judge, good morning.
Good morning. Recalling the matter of the people versus Nikita Wallace. These are tickets number ZH0826, count 1. Interfering with government employee performing their duty, count 2. Impeding pedestrian and or vehicular traffic. This is a hearing not scheduled for today. Attorney Burton Harris called and asked the courtroom if we could come on the record today to try and see if we can figure out the filings made as a part of the hearing set for today. This morning, some dates council believes may have been an error, and I was listening to arguments, Attorney Walker, to see what was the error and what may have happened. I had to go upstairs to get my transcripts from the last hearing date of November the 29th to find out exactly what occurred that day, to still try and remedy and figure out exactly what it was that took place. So from reading my transcript, this is what I got out of it. I got that on this date and time, as the court did say that certain people were going to be asked to testify during a hearing proposed for July 14th of 2022. That had been at the beginning of this year. So in the interim, a stay must have been filed. And if I'm believing correctly, because I don't have any more hearings at this point in time. So a stay was entered, not on this day, but later on down the line. I'm hearing July 20th. Okay, that's what has been told to me on this document. So I'm trying to figure out where the court erred, because I have that we haven't had this hearing yet. The last hearing I have is November the 29th. Am I correct?
That's correct. That's when the last hearing was.
Okay.
I'm sorry. So
Yeah.
November 29th was the last hearing before the city filed their motion to stay proceedings. There was another hearing, I think, on January 6th, because obviously we had to deal with that before the date of the evidentiary hearing that was originally set for January 14th. And at that January 6th, 2022 hearing, that's when you granted the city's motion to stay. So it wasn't July, it was January 6th, and you are the one who granted that motion to stay.
Okay. So what's the difference? Does it need to be corrected to January the 6th, even though it was filed? Because it was filed right before we went on break. That's why it wasn't heard.
Right. So, and Ms. Walker, this is the crux of what I was correcting, or what I'm asking to be corrected, is the order from the December, that's dated December 20th, 2021, where the court ordered the evidentiary hearing. I was saying that this is a scrivener's error because the order was actually made on November 29th, 2021, and entered into the register of actions on that same day. Notice to appear were sent out. And then on December 20th, I believe the city attorney came in and got an order signed, but with the December 20th, 2021 date. And it says in the order, quote, at a session of court held in Detroit, Michigan, County of Wayne, State of Michigan, on December 20th, 2021, this matter having come before the court, et cetera. There was no hearing on December 20th. The only hearing that we had was on November 29th, 2021, and that's when the order was made and also entered. So the order, the memorialization of that order should reflect the November 29th date and not December 20th, 2021.
But Judge, just briefly, Shannon Walker on behalf of the people, my P number is 53794. Just real briefly, I guess, starting with this, this is brand new. This is the first time this has been heard by the people. That being the case, the people would automatically just go to MCR 2.119. This is a motion made outside of trial or hearing. Council needs to put that in writing and provide it to the people, give us an opportunity to respond. People looking at transcripts, looking at court entries, looking at those kind of things without the people having the same opportunity is patently unfair. So that being said, that would be the people's first request, was that this motion be put in writing and served on us so we can do the same research that council has had the opportunity to do. And secondarily, Judge, this is, being brought up on the eve of hearing the motion at noon in front of the circuit court. This almost seems like a last ditch attempt to not have that motion being heard. That motion has been scheduled, it's been heard. There were plenty of opportunities for previous council to make this motion prior to this date if that's what they chose to do. So minimally, Judge, the people would ask that this be put in writing, given the exact law that's behind it, the facts that are behind it, and give us the appropriate opportunity to respond. This was not noticed for today's date.
And Judge, just to respond briefly, so in other situations, I would agree with Sister Counsel that this would be more served better and maybe in some type of written motion. But number one, I just got involved in this case, so it's not like I've tried to surprise Sister Counsel. The 2.119 is the court rule dealing with motion practice. That's not controlling here, because what I'm asking is for the correction of a clerical error of an order. The controlling court rule is 2.6112, subsection A. And it specifically says that you don't need a motion from any party to correct an error in an order. You can actually do that sua sponte without anybody bringing it to your attention at all. Subsection 2 of that court rule specifically says, quote, if a claim of appeal is filed or an appellate court grants leave to appeal, the trial court may correct errors as provided in MCR 7.208, subsection A and C. So in this case, we do have the city attorney who's actually filed leave to appeal. The leave to appeal motion has not been granted yet. So if you go to 2.0, subsection A and C, Section A specifically allows for the correction of these type of errors. And also C actually gives more of the court a latitude. It's titled correction of defects, except as otherwise provided by rule, and until the record is filed in the Court of Appeals, the trial court or tribunal has jurisdiction to correct any part of the record to be transmitted to the Court of Appeals. So obviously this isn't going to the Court of Appeals, this is going to the circuit court. Because the court rule is in the district court to the circuit court appeals section and makes reference to this specific court rule, you can change and correct that error, especially when you are the one who granted the motion to stay. If the circuit court had granted the motion to stay, then we wouldn't be here. You wouldn't be able to even correct a clerical error in the order. That's not the case. So because of that, and because it's uncontested when these things occur, Your Honor has the transcript. The December 20th date, because there was no hearing held, that date should never have been on the order at all. Now, again, I understand Sister Counsel's position and feeling like this is a surprise. It was a surprise to me too, only because I just got involved in this case. I filed an appearance maybe an hour ago in the circuit court. So there was just no previous opportunity for me to raise this. And you know how complicated this case is, and Mr. Royal and his help. I don't know why this wasn't.
Mr. William Harris, okay, all right. So I've tried to figure out what it is exactly. And I can appreciate your zealous advocacy for them, but asking me to figure out what exactly the order was, have the file pulled, have it brought to me so I can read it appropriately this morning. When you filed your appearance this morning, the appropriate latitude would be to ask I barely have jurisdiction right now to make rulings because it is in the Court of Appeals. They haven't accepted it yet. But this would be the appropriate argument to make to them this afternoon, saying that you're new counsel and you want to explore some issues that may have arisen. I don't feel comfortable just changing stuff right now, especially when my transcript and everything, and I want to see the actual order. I don't have the actual order because I don't have the actual file in front of me. And so before I just start granting stuff and saying, okay, I don't. So my remedy for today is that maybe ask the circuit court, since you just newly have been on this case, if you can have some additional time to be able to foster through some issues you now see as new counsel and new and fresh eyes, and be able to bring that back to us as an appropriate hearing at a later time, where I can have the file pulled, I can look at the order and see what order it is that I signed, and see if we made some type of error in setting this order based on what was signed into the thing right now. Because right now, all I have is my register of action, and it's saying all the dates. So I guess I'm a little out of tune with what exactly it is. I know what you're asking for, but I don't even know where it's at in the order because I don't have it. All I have is the written order, the written answer or not response, but the written portion of it why they're requesting the stay. So I don't know what the order looks like. So I do know that
I appreciate that.
at noon. I'm sorry that you sat on so long. I thought it was something quick like an error. I didn't realize it was a question about when certain things had been filed. And so in order for me to process that and see that, I need to have the actual documents in front of me. So
I appreciate that.
Yeah, all I'm saying is that you need to maybe ask for additional time so that I can be able to actually see what it is and see if I need to make that corrective
Sure,
action.
I totally understand, Judge. And I have a copy of the order. And I understand the respect if you don't want to do anything with this issue now. But I can email it to you if you need, if it's not in the file for whatever reason. And I was just trying to save, the court some time, because what's going to happen is I'm going to ask for the case to be remanded back to you to fix this error. And so I was just trying to save some time. So that's why I contacted the court and asked your preference for how this matters.
Tell me to fix the error, Mr. Burton Harris. Let the court tell me to fix the error.
All right, I'll do that then, Judge. What's the, do you want me to just send it to the court's email address?
Yes, I'm gonna give you 2 email addresses in chat. That
Okay.
way you can send it to us. I've sent Jet my email as well as my court clerk's email, so that way she'll be able to print it out for me so that I can review it. Attorney Walker, if you want a copy of that, I will make sure that you get a copy as well. And,
Yes, Judge.
Just gets a copy of it as well, and then we'll see what happens at the hearing on today. And then we'll move forward from there. But I just hate to make a hasty decision. Even though you're sending it to me, I would like the opportunity to be able to read the order and figure out what it is. And I'll follow the law. So whatever the law tells me to do, I'll make sure to follow. So if there's nothing further, that does conclude this hearing.
Thank you, Judge.
Thank you. All right. Ms. Walker, can you stay on for a minute?
Yes.
All right. We have this wonderful person who signed in, and she has some additional tickets. Some of them she paid for already. But some of them so she signed in because she thought she had 1 ticket, and she really has a pending ticket that's to be heard for a hearing next month. And she has 2 civil infractions and a misdemeanor and another misdemeanor open. She has proof of her insurance now, from my understanding, and possibly her plates. Does she have plates proof too, or no?
No, the insurance was the only ticket on the docket. So I didn't ask about her plates, but
Yeah.
I think she would. I'm not sure though.
She has expired plates. plate, and then an 11 to 15 miles over posted speed, and a failure to yield right away. I don't know if you want to do anything, or you want to see if somebody else can do something on another day.
I can do it. Would you prefer me to come down and write a written offer? Okay, I'll head down to the courtroom right now.
Thank you.
And I'm just checking if she has registration as well.
Okay, sounds
Okay,
good.
thank-
She does have her registration. I don't know if the prosecutor's in the courtroom.
There you go. You can tell
I
me.
am in the courtroom. I got it.
Okay, so she has her registration that expires next year, March, and then the insurance expires in a few days, but it's valid now.
Really good.
Judge, where's handwritten page? I mean,
Okay.
Thank you so much.
Is that all?
That's it. Thank you so
You're
much.
welcome. You're welcome.
Attorney Carver,
Yes, Your Honor.
see if she will do, limited access 60 and a 55 on the speeding ticket she has is 11 to 15 miles over posted speed. So
Wait,
that's
did
the
I miss
5.1.
one?
Huh?
Did I not see that ticket? Because I was doing the failed and yield. Did I miss one?
This one, hold on a minute.
I missed
Okay.
one. That's
Hold
what
on.
happens when I didn't bring.
All right. So it's going to be on the
Failed and yield.
Delta yield, it's gonna be amended to a 60 and a 55 limited access, so that's no points, but it is a fine of $125. See if she wants to do that. The balance of the tickets will be dismissed.
Okay, great.
Okay,
I'll be right back. Thank you.
no problem.
She would like to accept the plea offer.
Okay, fantastic. All right. Miss Sandy, you ready? Now calling the matters of the people versus Melody Wilson. This is ticket number P1273920. Count 1, failed to yield right of way. Count 2, no insurance misdemeanor. Count 3, expired plate. Ticket number P1232973. Count 1, no insurance misdemeanor. And ticket number SP1377321. This is 1 count speeding 11 to 15 miles over posted speed. This matter is not set for the record. It is scheduled for a hearing on September the 12th, 2022. Appearances for the record, starting with counsel, please.
Jane Carver on behalf of Ms. Wilson. Ms. Wilson, can you state your name for the record, please?
Melody Michelle Wilson.
Ms. Wilson would like to take advantage of the offer and enter a plea today.
Is that correct, ma'am?
Yes, that's correct.
If so, can you please raise your right hand for me, please? Oh, no, this is a civil infraction. So ma'am, what I'm going to do is I'm going to read from the ticket to establish a factual basis and then give you a fine that goes along with that ticket. You understand?
Yes, I understand.
All right. Your reception is a little bad. If you could get a little closer to your phone, that would be great. Okay, ma'am?
Okay.
All right, there we go. So on the date of November the 4th of 2021, in the area of Seymour and Gratiot Avenue in the city of Detroit, Ms. Wilson was driving a GMC vehicle And she did do limited access 60 and a 55 mile per hour zone. Satisfied?
Yes,
Satisfied.
correct. Yeah, satisfied.
Council satisfied?
Yes, Your Honor.
Thank you. Stipulation of probable cause on the remaining counts to be dismissed, council.
Yes, stipulated.
So at this time, the court is going to enter a plea to the amended plea of responsible to limited access 60 and a 55 mile per hour zone. The remaining 2 counts on that ticket will be dismissed, as well as the other tickets called on this record today. Ma'am, the fine for that is $125. Typically with civil infractions, you have 14 days to be able to pay it. Is that gonna be enough time for you?
Yes, enough time. Thank you.
No problem. So I'm gonna have to do no later than August 29th, 2022, okay?
Okay.
All right. If there's nothing further, that concludes this hearing, ma'am. Make sure you come on the court on time next time, okay?
Yeah, and yes.
Okay.
Okay.
All right.
Thank you.
If there's nothing further, that concludes the
Thank
hearing.
you.
You have, Ms. Wilson, you're welcome.
You too, dear. Thank you. Bye-bye.
Thank you. Bye-bye.
Thank you.
That's for you, attorney. She's thanking you now, attorney.
Thank you, ma'am. Have a good day.
All righty. Bye-bye.
All right, and that concludes this morning's docket, everyone. Thank you.